listening to the Agent Survival Guide podcast, a podcast for today's insurance agents. Informing, educating, empowering, improving the way you do business in an industry that's anything but static.
In today's episode, every client has a different situation and set of needs. It's your job as their agent to be aware of those needs and assist them with navigating their coverage. We're looking at clients with the unique circumstance of having a power of attorney or conservatorship, helping Medicare clients who have powers of attorney or conservatorships written by Cassidy Potts. As people get older, it can be hard for some to continue to manage their affairs. What happens when your client can no longer make Medicare decisions on their own? Throughout your career as an insurance agent, you may encounter clients with the power of attorney or in conservatorships. While you can't make decisions for these clients, you can help point them and their caregivers in the right direction. Let's take a look at powers of attorney and conservatorships, how they work with Medicare, and how you should approach sales presentations and enrollments for clients who have delegated decision power to another person. We'll start with powers of attorney. Also known as POA, power of attorney is a legal document that allows someone to appoint a trusted family member or friend to act on their behalf before they're unable to do so. The person appointed, the attorney, may be able to oversee your client's insurance accounts depending on the type of POA. Even though someone else is technically carrying out the tasks for your client, the POA sets the terms. Here are some different types of POA you may encounter. Durable power of attorney gives the designated person financial legal authority over your client, whether they are capable or incapable of making decisions. Legally, even a spouse cannot make Medicare decisions for your client without this. Non-durable power of attorney. The chosen individual will have financial legal authority over your client and ends if they become incapacitated. General power of attorney. The appointee can act in all situations allowed by local law, and this type can be durable or non-durable. Springing power of attorney. With this, the power only begins once a special condition is met. It remains in effect until your client passes. Financial power of attorney. The appointee can only act on your client's behalf regarding certain money and property matters of your client's choosing. Medical power of attorney allows the appointee to make healthcare decisions on your client's behalf. This is limited to medical care received. Since the appointed individual may need to make serious life decisions, they should be a family member or someone your client trusts. Many people add both their spouse and their children in the event one is unavailable. The only qualification is a POA can't be under 18. If your client decides they want to go this route, it's important to make sure they also know that it's not a permanent decision. Most states require written notice of revocation, but it is possible to remove someone as your attorney. As an insurance agent, your clients trust your guidance when it comes to finding coverage. We know you always have the best interest for your client in mind. However, if a client requests you to be their POA or conservator, you must politely decline. It is not ethical for agents to be the POA or conservator over their clients, as it constitutes a major conflict of interest that can result in criminal penalties. Moving on to conservatorships. What is a conservatorship? This type of legal arrangement happens after an individual unexpectedly becomes incapable of managing their finances or personal life. In a conservatorship, a conservator is appointed by a court to oversee someone who is incapacitated. A friend, family member, or public official can petition the courts to appoint a conservator. The petition details exactly why the individual is no longer able to make decisions for themselves. Then a court investigator interviews the proposed conservatee and decides if the need for a conservatorship is justified. If appointed, a conservator can make decisions about the conservatee's healthcare, finances, living arrangements, or any other personal matter. Generally speaking, a conservatorship can be terminated if the conservatee or another individual successfully petitions the court to have the conservator removed. The 2021 Britney Spears case certainly put the topic of conservatorships in headlines and under some tough scrutiny. However, this type of legal appointment may be beneficial for those in certain circumstances. Alerting Medicare of power of attorney or conservatorship. According to the law, Medicare requires the beneficiary's written consent to disclose their personal medical information to someone else, even a spouse. Your client can provide this consent by filling out and submitting the CMS authorization to disclose personal health information form. Upon submitting proper authorization to CMS, the named representative will then be allowed to discuss your client's information with Medicare and even elect coverage for your clients. It's important to note that representative payee status is not enough for someone to enroll your client in a plan. Your client will also need to complete separate authorizations for Medicare Advantage, Part D, and Medicare Supplement plans. Now, you might be asking yourself, are POAs and conservatorships recognized by Medicare? When it comes to issues regarding Medicare, the POA does not stand alone. Legally, a durable POA is beneficial because even your client's partner cannot enroll them in a Medicare supplement or prescription drug plan without it. On the POA document, it should also be clearly stated that the attorney has the power to enroll the beneficiary in a health insurance plan. If your client has a conservator, that conservator is legally allowed to manage all of your client's Medicare needs. All court documents should be sent to Medicare. Even if your client has a conservator or attorney, they still need to complete the authorization to disclose personal information form. Next, let's look at proof of representation versus consent to release. Since the conservator or POA might want to communicate with and provide information to the Benefits Coordination and Recovery Center, BCRC, they will need proof of representation. This will then allow them to respond to requests, receive a recovery claim, file an appeal, and submit information on the beneficiary's behalf. A consent to release, on the other hand, only allows the attorney or conservator to receive information but not act or make decisions for the beneficiary. If a conservator or an attorney wants to obtain proof of representation, they must provide the proper legal documents that show their status as a conservator or attorney. If the beneficiary is incompetent, it's important to note that a durable power of attorney is needed. How agents work with an attorney or conservator. Even if your client has an attorney or conservator, you should still be taking all of the same steps as before to make sure they are receiving the right service, care, and coverage available to them. However, the way to go about these steps will likely change. One of the first steps you should take is making note of the contact information of the attorney or conservator in your client's platform record. This will allow you to easily connect with the person responsible for making decisions on your client's behalf. As an agent, you should always have your client's best interest in mind. It's particularly important to protect clients that may not be able to advocate for themselves. Unfortunately, having a POA or conservatorship can leave individuals susceptible to so-called help from those who may not have their best interest in mind. The U.S. Government Accountability Office found hundreds of allegations of abuse by guardians in 45 states and the District of Columbia between 1990 and 2010. Often, the courts may not be able to oversee guardians or communicate effectively. According to research, approximately 1 in 10 Americans over the age of 60 living in a community has experienced elder abuse. They also found that an estimated 1 in 24 urban cases and 1 in 26 rural cases are reported to authorities. Even though a POA and conservatorship are supposed to help your clients make decisions, there's still the potential for physical, mental, emotional, or financial elder abuse. The Spears case brought national attention and changes to conservatorships, but didn't fix the system completely. If you are aware or suspect that a client is experiencing abuse, you can file a complaint to your local law enforcement agency or petition the court to respond to the mistreatment. They can then take appropriate action to replace or terminate the conservator or POA. You want your clients to be in control of their health. However, maybe they need more assistance than you can provide. Maybe they have a POA or conservator or would like to plan in case they need one in the future. Understanding their situation and making sure all involved in your client's health insurance decisions are aware of the options allows for the best enrollment decision now and in the future. Remember, here at Ritter Insurance Marketing, we're here to help you and your clients. You can partner with Ritter for free to unlock our support and industry-leading sales tools. Learn more by visiting the link in the episode notes. Thank you so much for listening. We will see you next episode. The Agent Survival Guide podcast is a production of Ritter Insurance Marketing, an integrity company. This episode was written by Cassidy Potts, recording and production by me, Tina Lamoureux, script proofing by Sarah Ruppel, podcast design by Urban Rivera, artwork by Vivian Zhao. Rate and review our show on Apple or Spotify.